Namaste ji, namaste. Welcome to Courtroom. Hope you're doing well. So the following series of lectures was part of our online program for the UPSC Law Optional. But since we don't teach for that specific subject anymore, I have decided to put all of those lectures from our website on YouTube. So एक मैं पूरी playlist I'll create it, and then you can check it. You can check the links, etc., in the comments, in the iCard above, etc. And it will really help you in even in your LLM preparation, even in your judiciary preparation and law optional के लिए. So these lectures were specifically created for the law optional. They can also help you for your semester. However, if you're preparing for your LLB entrances, I say skip them because it is too much detail. You'll get confused, and stick to the basics for your LLB entrance. Alright, so I'll create I'll put this clip in front of each and every lecture that will be posted on our channel, so that you can check the playlist, etc., and it makes sense what is happening with these lectures. Alright, so it is a sequence. Try to watch them in a sequence, and hopefully you clear and get very good marks in your optional in the UPSC. Take care, bye. Namaste. So in the constitution portion of the UPSC Law Optional course, let us discuss the ordinance-making power of the President by discussing the question. Now you see, all of these topics we can go into the length and the breadth, but that is more suitable for, let us say, a semester level examination, or if you're doing a PhD, etc., in law, when you're writing a thesis. Herein we are focusing on a 15 marker, so it's a 225 to 250 word answer that you will write, because for a 10 marker they expect you to write it in about, roughly speaking, 150 words. So applying logical deduction, we are looking at a 250 marker, or rather 250 words, not 250 marker. 250 marks milenge to maza hi aa jayega ek mein. But anyway, discuss the ordinance making power of the President. This is a question from 2019, and I want to approach this topic with taking the question as the background. So the examiner basically is asking or is expecting us to write what is an ordinance making power, right? Why is it there? What is the intent of people who framed the Constitution to basically give this article any prominence in the Constitution? The what and the why, and where is it given? Because without the where, we really won't be able to demonstrate to the examiner that, hey buddy, we also know what you're trying to do here. Can the validity of an ordinance be challenged in the court of law? So we'll have to, obviously, even if this sentence isn't written, cite relevant case law, we'll have to write case laws. So two things. Where is basically the ordinance making power given in part 5, chapter 3 of the Constitution? What is part 1? So let us revise. So you have prelims ki bhi dobara se revision, and basically for your GS as well. Part 1 is the Union and its territories. Part 2 is citizenship. Part 3 is fundamental rights. Part 4 is DPSP. Part 4A is fundamental duties. Part 5 is the Union. Chapter 1, the executive. Chapter 2, Parliament. Chapter 3, legislative powers of the President. Correct? This is how the Constitution needs to be on your tips for the prelims as well, and for the law optional as well. Now we'll come to the must mention, etc. baad mein. But we have to start with the what, the why, and the where. This is how we are going to approach this answer. So this question can take multiple forms. So they can ask you to contrast the powers of the President and the Governor to issue an ordinance, all of that. So we'll come to the ordinance making power of the Governor in the next one, and then basically you can combine the knowledge from this lecture and that lecture to frame out a beautiful answer. If such a question is there, we have to answer that. Why? Because it's a very easy question, and you can't leave all of this. So we'll come to the must mention later. Now when we are here, the legislative power of the central executive, you will stress to the examiner in your answer that you know that it's a legislative power and this is not an executive power. Alright, so this is the way in which the central executive is empowered to make a law. But why? That is the crucial portion that you will elucidate for the examiner. Alright, so you can start off your answer with ordinance is a legislative power of the central executive, which is of 4 types. The legislative power, that is, it's participation of executive in the legislative process, wherein just mention this, that they can prorogue and dissolve the house. The President can do so Point number 1, and that's it. ज़्यादा और जाने की ज़रूरत नहीं है, because the question is about the ordinance and we need to get to the ordinance very, very fast. So power of rule making. So who makes rules for joint sittings, etc.? Who has the power? Again, the president. And president is always working on the advice of the council of ministers. So therefore, the central executive is participating in the legislative process. Anyway, no need to elucidate point number 1, point number 2. Just write these mini pointers so that the examiner knows that you are in the correct direction. Power to proclaim an emergency, again, 356, 352 to आगे जाएंगे तब discuss करेंगे. But power to make ordinances. I had to make a quick edit because of the background noise any which way. This is the point that is going to fetch you marks. Now, you cannot write this answer without citing R.C. Cooper, which is basically the bank nationalization case. Whether you mention any other case or not, it's really of no relevance. But if you can mention one more, we'll come to that. This technique has been devised to enable the executive to meet any unforeseen or urgent situations arising in the country when Parliament is not in session. Keywords to note are ये आप बार बार लिखेंगे, urgent or unforeseen situations, right? When Parliament, now, think about it. Why is this basically power given to the executive? Why? Because let us say, Parliament is not in session and they need to make some emergency arises, some very immediate situation arises in which they need to pay attention to, and the problem can only be solved by passing a law, and Parliament is not in session. We can't really expect or rather wait for the Parliament to be in session and then only can we tackle the situation, right? So unforeseen or urgent situation arising in the country when Parliament is not in session, and when such a condition cannot be dealt with under the ordinary law. I want you to write these 3 or 4 lines in an answer on ordinance, all right? तो ये आप काम करेंगे, right? Now, whether you write this line or not really doesn't matter. Ordinarily, the president is not the repository of the legislative power. ठीक है जी? Usually it is vested where? In Lok Sabha or Rajya Sabha. Then you're going to mention part 5, chapter 3, or in fact, even if you don't want to start your answer like this, you can start the ordinance making power is a legislative power of the president given in part 5, chapter 3 of the Indian Constitution, and then quote the article. You're going to quote 123 and you're going to quote 213 as well. What is 213? The ordinance making power of the governor. So this will basically turn out to be a very beautiful answer. Now, again, language is crucial in an answer. But to tackle extraordinary situations demanding immediate enactment of the laws, the president has been vested with such power by the makers of the Constitution, and ordinance is a temporary law. Hopefully it is clear. Now, I don't expect you to rote learn this and keep this exact one-to-one language. That's absolutely not the point. All that you have to explain is the immediate enactment of the laws and why the president has been vested with such a power, and why are we exactly participating in the legislative process. Because if Parliament is not in session and such a situation arises which demands a law, we need not wait for the Parliament to come back in the session, and the president can issue an ordinance, and it is very frankly, it's a temporary law, correct? Quote part 5, chapter 3, quote article 123, quote article 213, and we are going to quote article 114 clause 3, provided that you can remember this. Now, chapter 3 is legislative powers of the president. Let us discuss the article a bit. हम आंसर से थोड़ा परे जा रहे हैं इस टाइम, just for your knowledge sake, so that you can elaborate the answer on your terms. If at any time, except when both houses of parliament are in session. Now, why do you think this clause is there, except when both houses? Because usually the legislative power to make laws, to enact laws is, well, फिर parliament है क्यों, correct? If parliament is not in session, तो हमने president को, we have, this is almost like an inverter sort of a system. The electricity goes off, well, we have the president to take care of it. As in, not the president is not going to fix your electricity, of course, but hopefully with the analogy, and obviously don't mention this in your answer. The president is satisfied The key word here is satisfied. And basically वो जो क्वेश्चन के अंदर अभी आते हैं, जरा एक बार दोबारा क्वेश्चन खोल के देखते हैं, ये satisfied पे जरा ध्यान रखिएगा इस चीज को. That circumstances exist which render it necessary for him to take immediate action. He may means up to its discretion promulgate such ordinances as the circumstances appear him to require. Now let's go to the word satisfied. Can the validity of an ordinance be challenged in the court of law? All case laws are basically based on this very word satisfied, and therefore to explain this portion we'll have to elaborate a bit on the word satisfied using a case law. Alright, so discuss the ordinance making power of the president. So we have discussed it, we know, we have told you it's a legislative power, correct? We have told you where it's given, we have told you, we're talking to the examiner basically, told you that the governor also has it. We also know that it's in part 5. We also know it's in chapter 3 of part 5. मतलब और माइक्रो डिटेल हमने इनको करा के दे दी है. अब हम जाते हैं जी इस पे आगे. Okay. It shall have the same force and effect as an act of parliament. It is the same thing as a kanun, but it is a temporary law. Okay. It shall be laid before both houses of parliament and shall cease to operate at the expiration of 6 weeks from the reassembly of parliament. Now you can write this in your own language. Just mention article 123. We are not testing you whether you can remember the article word to word. How many articles can you remember from word to word? Prelims भी देने हैं भैया, बाकी पेपर भी हैं. This is only an optional. कितना दिमाग लगाएंगे यहाँ पे, word to word नहीं रखना. But you do let the examiner know that as soon as parliament comes back to session, right, 6 weeks from the reassembly of parliament, or from the later date, we'll just come to the later date, or before the expiration of that period, the period resolutions disapproving it passed by both houses upon the passing of the second of those resolutions. Basically now the houses have basically blocked the ordinance and said, well, go away. It may be withdrawn at any time by the president. Crucial point that you will mention that it can be withdrawn anytime. So once it is issued, it can be withdrawn as well. All right. Explanation. Where the houses of parliament are summoned to reassemble on different dates, the period of 6 weeks shall be reckoned from the later of those dates for the purposes of this clause. Meaning, if Lok Sabha and Rajya Sabha basically, they reassemble at different dates, तो जो later वाली date है, उसके ऊपर से हम 6 हफ्ते अपने, we are going to calculate that. So be smart here and say, from Article 85, so the maximum, we are using some law about amount of deduction here, the maximum time period of an ordinance is 7.5 months. Why 7.5 months? Where is exactly is this coming from? 6 weeks is, month has 4 weeks, right? 6 weeks is 1.5 months, correct? Parliament has to meet compulsorily within once every 6 months, Article 85 says so. Whether you mention Article 85 at this stage or really doesn't matter, you mention 7.5. So under any and all circumstances, an ordinance won't be able to basically extend further than 7.5 months. Why? 6 mahine plus 6 weeks. Hopefully it is clear. If it is not, then use the discussion board. I'll explain the formula to you. 123 हो गया. 213. अगर गवर्नर के बारे में उन्होंने नहीं पूछा है, बट सिर्फ एग्जामिनर को बता दीजिएगा कि गवर्नर की पावर, you know that it's given in 213. But otherwise, no need to elucidate on the governor power unless and until the question is actually asking you to contrast the power of the ordinance making power of the president and the governor. Okay. Now we come to our case law bit. And इसके ऊपर this answer you have to write. If it appears in the exam, and let us say that it's part of question number 1 of 5, wherein you are writing a compulsory, you will have to attempt those questions compulsorily, write this answer. This is a very beautiful answer, and it's basically, there is no, I would say, vidambana or confusion or anything like that in writing this answer. Now let's go again. Herein, you start off with the case law. So you cannot write an answer on ordinance without quoting R.C. Cooper versus Union of India, also popularly known as the bank nationalization case. And I already know that you have read to this for your prelims as well. But nahi padta kya kare. Now, herein, this is a 1970 ka case. The Supreme Court observed in this one, it is in truth promulgated. Basically, the Supreme Court pondered about, वैसे नाम तो president का लग रहा है, that the president has the power. But it is in truth promulgated on the advice of the Council of Ministers and on their satisfaction. Relevant ordinance के लिए in the GOI Act 1935 was section 72, relevant provision that is. Now, our constitution is basically, it grew out from GOI Act 1935, and I'm sure that you have studied Lakshmikant and I don't need to elucidate on that. So, in that also we had given the power to the Governor General to promulgate an ordinance in cases of emergency. Okay. Now starts the story that can you actually challenge an ordinance in a court of law? So in SKG Sugar Limited versus State of Bihar, write this case law down. If you cannot manage to remember, it's absolutely okay. We'll come back to R.C. Cooper in just one bit. So in SKG Sugar Limited versus State of Bihar, which is a 1974 case law, the Supreme Court said, well, the necessity of an immediate action. So herein basically we're talking about the governor. Promulgate an ordinance, the sole judge is the governor, and this is not a justiciable matter or justiciable matter, justiciable rather, not justiciable, justiciable matter. We cannot look into, the mind of the governor. If he's satisfied he's the sole judge, this is what the Supreme Court said, but then, Supreme Court barely ever tickles in on its own words and keeps on getting, confused and keeps on overturning its own words often. Whether you mention this case law or you don't mention this case law really does not matter. Write it down, notes में है, याद रह गया ठीक है लिख दीजिएगा, नहीं तो otherwise for 15 marker. Come to this, the bank nationalization case in which basically we were challenging the banking company's acquisition and transfer of undertakings ordinance 1969. So let us say in your exam you forget this portion, the bracket wala acquisition and transfer of undertaking, कोई बात नहीं, absolutely fine. You just write banking company's ordinance 1969. We had challenged this in the R.C. Cooper case. Now the main argument, the main plea before the Supreme Court was that the condition precedent for Article 123 to come into effect, that is basically the condition that is required for this article to even come alive to be of applicable to any case, is missing here. Now the government argued, well, hey buddy, and government will argue via who? The Attorney General, Article 76. Subsequently revise hota rahega. That, well, this satisfaction, remember the word satisfied? It is subjective, right? And we are under no obligation to tell you that whether how we were satisfied and what are the conditions. Otherwise, so every, we'll be sitting in court at every stage of a lawmaking process, correct? Now, the political times was such that the Supreme Court, remained away from that question ki nahi, chalo chhod dete hain, because, those were very turbulent times. The CJI was missing sometimes. There was questions about dissents. There were questions about, Mr. Judge Khanna's CJI-ship basically being eaten up by the government. There was basically a hell lot of political turmoil in the country. Back then, Indira Gandhi was in power and basically the judiciary was under attack, and judiciary and the government were basically at loggerheads over what all was happening in the country. So Supreme Court says, well, since Act has already been passed, so after the ordinance, the Parliament reassembled and they gave its assent. Now the Act is already passed. Now the question had become academic, so it refused to touch on the question that whether that satisfaction of the president, whether such circumstances exist, is now merely academic. As they said, now the Act is already there, and what can we do about it? So we'll just leave it be. Okay. Therefore, now the Indira Gandhi government basically said, "Ye to bahut zyada gadbad hai. Ye to this way, to people will keep on approaching the Supreme Court and keep on challenging us like this, right?" So they introduced via 38th Amendment, Clause 4, and said that such satisfaction of the president is non-justiciable. Simple as that. And after that, Supreme Court said, no, that is okay that satisfaction is non-justiciable, but we can still question you on ground of malefides, because if we can question the emergency, Emergency can be challenged, correct? The declaration of emergency can be challenged. Similarly, for malefides, we can still justiciable. But the 44th Amendment basically deleted this NJ wala clause. आपका काम खत्म कर दिया 44th Amendment. So अभी तक हमने क्या क्या mention करना है? RC Cooper case 123, 213, correct? 38th Amendment, 44th Amendment. थोड़ा थोड़ा धीरे धीरे करके. Basically अब ये नहीं जाना कि 38th Amendment की you write a PhD thesis on that. No, just the relevant portion about the ordinance and clause 4 under Article 123. ठीक है जी? And this will make a very beautiful answer. Now this is just for your knowledge. Just for your knowledge, in A.K. Roy versus Union of India, it's in 1982, we challenged National Security Ordinance of 1980. Again, the Supreme Court left the question open that whether we can actually look into the merits of an ordinance, whether the satisfaction of the president, etc. Now, because again, the act had come into force, but they hinted. So there was basically a component, an obiter. Obiter is a general observation. Ratio decidendi is basically the rationale of giving the judgment, in which the government basically provides you reasoning. But an obiter is just a passing observation. You cannot legally enforce it. They said, the ordinance making power can't be fully out of the judicial review, and malefied, you can't use it with a malefied intent against the normal legislative process, because the president can overpower basically the legislative process. So the proclamation of emergency under Article 356, can it be challenged? It can be challenged on the grounds of malefides. Yes, this was held under S.R. Bomai, but pretty much you won't have time to write all of this. So I'm just not interested in giving you more and more gyan and then asking you, ये सब लिख लेना, time कहाँ होगा आपके पास ये सब लिखने का? जब time नहीं है, so we'll have to be very focused, right? Now, if you can mention this case law, अगर आपको ये याद रह जाए, so along with R.C. Cooper, this one, A.K. Roy नहीं करना है, SKS Sugar नहीं करना, that was just for your knowledge and just for your general awareness, you can say. So this is T. Venkata Reddy versus State of AP. This is 1985. Herein, whether you can remember the case law name or not, I really don't care, but you will have to remember these points. That the ordinance is a legislative act, basically. It's not an executive, you can say, in power or mode of enactment. It is basically legislative in nature, right? So it cannot be questioned on such grounds as improper motives, etc. This is a 1985 ka case law. So this is happening, in a sequence though. This is happening much after the R.C. Cooper case. So an ordinance acts on the same footing as an act, as जैसे लिखा हुआ था वहाँ पर. तो वो कह रहे हैं कि since when did we start questioning the motives of the parliament in passing an act? Article says it has the same effect as an act. So since when did we start questioning the motives of the parliament? If the act is unconstitutional, it is ultra vires, we'll declare it. So we have the power of judicial review from Article 13, correct? But since when? So how do we? So ordinance is also pretty much the same thing. So we are actually, whenever you are challenging an ordinance, you are not exactly challenging an executive action, you are actually challenging a legislative process, a legislative action. So if the act or if the ordinance is unconstitutional, basically it's ultra vires, the constitution, let us say it violates fundamental rights, correct? So, you can come to the court. So the court held, but we cannot question into the propriety. What is propriety? Zara Google में जाके अपनी vocab में add कर लीजिए अगर आपको इस शब्द का मतलब नहीं पता. I'm not going to tell you that. Do some homework. Propriety of the exercise of the legislative power. ये शब्द मेरे लिए यूज करना तो बड़ा आसान है, लेकिन अगर आपको एग्जैक्ट मीनिंग नहीं पता, गो टू गूगल, तभी याद रह जाएगा. अदरवाइज मी स्पून फीडिंग यू फिर भूल जाएंगे. ठीक है जी. बट कैन नॉट इंक्वायर इनटू द प्रॉपर्टी ऑफ द एक्सरसाइज ऑफ द legislative power. So basically they are saying, well, hey buddy, the ordinance is an act. So just like we challenge acts in the court of law, we're going to, you can approach the court of law in the same manner. But when was the last time, or can the court actually inquire into the motives of the parliament in passing an act? Well, it can't do so. So if it can't do so in the case of an act, how exactly are we going to do it in the case of an ordinance? That's what it's pretty much saying. Okay? So the motives of the legislature is beyond the scrutiny of the court. And I believe let's skip Nagaraj versus State of AP. Basically, this was held there. but this I think pretty much you can include in the point above as well. ठीक है जी. Rameshwar Prasad versus Union of India 2006 is a very recent case law. I just made a note of it. I don't think that I need to teach you that. But what I do need to teach you is here. Is ordinance making power undemocratic? This is R.K. Garg versus Union of India. So the Supreme Court said, well, if it's undemocratic, the Council of Ministers, in effect, the Council of Ministers ही काम कर रहे हैं, right? And they are answerable to the Parliament. And if they misuse their ordinance-making power, the Parliament can always pass a no confidence motion against the Council of Ministers, and well, the PM goes, so the Sarkar goes. But whether you want to write that, whether you don't want to write that, doesn't really matter to me. What matters is if you can remember the T. Venkata Reddy case law and elucidate on the point on the challenge. You are going to explain the satisfaction portion from R.C. Cooper. You are going to then talk about T. Venkata Reddy versus Union of India a bit. No need to go into the facts of the case. Just say T. Venkata Reddy versus Union of India. The Supreme Court held that the act is basically the ordinance making power is a legislative action, and the ordinance has the same, is basically in the same footing as an act. So therefore, we can't, since in the legislative process of passing an act, we never really question the motives of the legislature. So same applies in the case of an ordinance as well, right? So you basically elucidate two viewpoints of the Supreme Court on this matter. And I believe you will fetch a high amount of marks. When can you not pass an ordinance? So this is basically for your prelims as well, and general knowledge of polity. As Article 114, Clause 3. You cannot, so no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law passed in accordance with the provisions of this article. So you cannot pass an ordinance to withdraw money from the Consolidated Fund of India. ये आपने लिख दिया, examiner will like, क्या candidate आए, इसको 280 प्लस देंगे. List 1 के अंदर मैटर के अंदर आप ऑर्डिनेंस ऑफ कोर्स 7 शेड्यूल कर सकते हैं. लिस्ट 3 ऑफ कोर्स कॉन्करेंट है. लिस्ट 2 में नहीं कर सकते. You cannot issue an ordinance unless and until, or basically for the topics listed in list 2, unless and until national emergency is in place. Then obviously, because in an ordinance, the president / council of ministers or president plus council of ministers is actually assuming the role of the parliament. So parliament, whatever the parliament cannot do under normal circumstances, even these guys can't do. Correct? And that is also given in the article. Let's take a quick look at that and then basically close off this lecture. Let's go to 123. Yeah. If and so far as an ordinance under this article makes any provision which Parliament would not under this constitution be competent to enact, it shall be void. Okay, now we come to our first page. Calendar mein khul gaye hain. Let's just remove the calendar to here and see this. So you are going to mention, give me 1 second. You are going to mention 123, you will mention 213, you will mention 114 clause 3. You are going to mention, well, that it is a legislative power. You are going to mention part 5 in chapter 3. You will mention R.C. Cooper. You will mention T. Venkata Reddy, and you are going to close off your answer in about 250 words. And you will be like, ये तो बोलना आपके लिए बड़ा आसान है. ये तो आपने इतना लंबा चौड़ा भाषण दे दिया. Whatever I have said, not necessarily that you have to include everything. But if you mention to the examiner the emergency situations, or rather the situations which demand an enactment of a law, and such a situation cannot be dealt with in ordinary law. So to deal with such a situation, we have given the ordinance making power to the president. You mentioned section 72 of the TLOI Act 1935 that the same power was given to the Governor General in cases of emergency, and such situations cannot be basically met with the ordinary legislative process in place, that is getting an act, getting passed by Lok Sabha, Rajya Sabha. हमें तो immediate चाहिए. So immediate and emergency वाली position, emergency in this, like it's a situation that demands an immediate enactment of the law, you would say, because emergency says the examiner can actually उसका दिमाग emergency की तरफ जाना शुरू हो जाएगा. National emergency in 352, 360, वो सब हमने काम नहीं करना है. 123, you're going to show him where this provision is given. Then governor key related provision you're going to show. Then you're going to mention the case law about the satisfaction and how in P. Venkata Reddy, Supreme Court has basically equated an ordinance to an act and basically is trying to impose the same ratio or same rationale to what it would otherwise judge, or the same parameters of the judgment of an act, whether it's constitutional or not, the same to an ordinance, right? And I believe that you can find this up in 250. Start off your answer by elucidating that it's a legislative power of the central executive given under Part 5 Chapter, Part 5 Chapter 3 of basic Article 123 of the Indian Constitution. And then Article 213 में आप जाएंगे and Article 213 वहीं पे लिख दीजिएगा साथ में. And then you will start off basically why this power has been given. If you can remember Section 72 GOI Act 935, let us say, and this is going to happen in the exam, that you forget Section 72 GOI Act 935 yaad reh jayega, and this happens to all of us, whether it's judiciary examination, whether it's law optional. This is going to happen because it's not humanly possible to remember so many sections etc, because IPC भी है, Contact Act भी है, सब कुछ है. It's okay. So GOI Act 935 तो mention कर ही सकते हैं ना, section तो नहीं. GOI Act 935 तो हमारी that's like our best buddy from the polity and prelims preparation that you must have done, and even to write the law optional. So mention that again, for emergency situations the ordinance making power is there. And then you elucidate RC Cooper. Again, no need to enter into massive amount of details for the case law. Just mention what the Supreme Court held in RC Cooper, mention what the Supreme Court held in P. Venkata Reddy. That's it. आराम से आंसर लिखा जाएगा, right? And I believe that we have written a very, very good solid answer for something such as this. Discuss the ordinance making power of the president. What, why, where. This time discuss आ गया ना question में. What, why, where आ गया. Can the validity of an ordinance be challenged in the court of law? Yeah, sure. But then you explain it with case laws. So satisfaction वाला word आपके explain कर देंगे. ये चीज़ explain कर देंगे. I believe that you would have written a stellar answer for the purposes of law optional. And I believe that you'll be fetching around. क्योंकि actually, if I were the examiner, I would give you very high grade of marks for this answer, but for 15 markers, so 5 number तो कभी देते नहीं, scoring at a 9 or 10, I believe that we'll take it any which way. 280 plus करने हैं काम, हमने तो वही काम करना है. तो अब चलते हैं जी ordinance के बाद. Let us now go into other topics. So we will discuss the constitution from the perspective of past year questions, ताकि topic भी cover हो गया, एक तरह से हमें आंसर राइटिंग भी आ गई. Alright, now see you. Let's also try to cover out abetment now in the IPC. तो एक एक करके पैरेलल चलते हैं. एक IPC में कर लेंगे, कॉन्स्टिट्यूशन में कर लेंगे काम. ठीक है जी, तो काफ़ी अच्छे तरीके से काम हो जाएगा. Alright, now see you in the next one. Take care.